to the account. It has to be a simultaneous ownership. And it has to be only between spouses. I can't add my mother-in-law to the joint account, even though I would really like to. Okay. So that's one reason that we will often have the clients own a tenancy by the entireties LLC or family partnership and have the investments placed in the LLC or the family partnership, so I don't have to worry that they title everything under that entity properly. Now, I have 8 common LLC planning errors from a May 16, 2006 publication we did. The first one being these tenancy by the entireties issues, pointing out that if you have a shareholder agreement and you've gone for a tenancy by the entirety situation, the shareholder agreement or the operating agreement of the entity may be contrary to tenancy by the entireties. For example, if Marcia and I and Frank and Kathy set up a company, and Marcia and I have 50% as tenants by the entireties, and Frank and Kathy have 50% as tenants by the entireties, but the boilerplate language in the operating agreement says that if any one member dies, then XYZ happens. Well, then it's not tenancy by the entireties anymore because Marcia and I don't have an exact unity of interest, because if one of us dies, it's different. So you have to be very careful in your drafting. Most operating agreements that we review that have been done by non-lawyers don't have proper language to allow tenancy by the entireties. And probably 40% of the ones we review by lawyers don't have the right language. So you have to be careful on that. And also, I'm just pointing out, your entity documents could also disqualify your S election, and they could cause you not to have charging order protection. So it's really important. I know there's a lot of CPAs on the call today. It's real important to make sure that your clients not only have operating agreements, bylaws, shareholder agreements, but that you have encouraged them to have them reviewed by a qualified lawyer. It doesn't take long to review them to make sure you don't have these problems. Okay, I'm attempting to scroll now to page 25. I may have to have Janine come over here and help me out. There I am. Okay, just had my cursor on the wrong page. With 4.5 minutes to go, page 25, another big mistake. If you own real estate outside of Florida, well, first of all, that may be the mistake in itself. Why the heck did you buy real estate outside of Florida? But keep in mind that most states don't have tenancy by entireties. So if you bought a vacation home in Georgia and you put it in joint names with your spouse thinking it was going to be a tenancy by the entireties protected asset, guess what? It's not protected. In fact, if you bought that house in California, it may be exposed 100% to the debts of either spouse, because that's the way California rules work. So you want to think about putting your out-of-state real estate into an LLC and have that LLC owned as tenants by the entireties. That's going to be much safer for you. And then if somebody files a lawsuit because they break their neck on the property, that you've got a firewall protection there. Now, the IRS can invade tenancy by the entireties assets and just about anything else we do. And student loans are not easy to protect either. So we like to do a lot of different things for clients. We like to not put all of their assets under one particular method of creditor protection in case that method gets legislated out of existence. Page 27, wage accounts. If you are the head of your household, which means that you provide more than half of the support of any one person besides yourself, then your wage check should be immune from creditors, assuming that it's earned in Florida. And then if you put that wage check into another creditor-exempt asset, it's not considered a fraudulent transfer. So a lot of clients come to us with a situation where maybe the client has $300,000 cash that's exposed to a creditor, and a jury trial coming up in a year and a half. Well, we'll say, spend down that cash, live on that cash, and we'll bank your wage check directly into a variable annuity or directly into a tenancy by the entireties account. Now, there's also something called a wage account, where the law says if you take your wage check and you put it in a wage account, it's going to be protected there for 6 months. Well, I never like clients having a separate wage account. Here's the reason. If the client's married then they can just do a tenancy by the entireties account, and they don't need to worry about the 6-month rule. Secondly, the law on the wage account is not yet 100% clear. If the wage account is only safe for 6 months, then is anything you buy from the wage account only safe for 6 months? So if the client wants to put that money directly into a variable annuity, or directly into a tenancy by the entireties account, or directly into a limited partnership, that's going to be safe, and you can eliminate that darn wage account. So we've got the information there. Page 30, what does a doctor do with their money? Well, there are a lot of choices, and I would just encourage everybody to go through the choices. Pension planning, has there been a really good actuary that's looked at a census? I don't mean your local stockbroker who may not know much about this. I mean, has a good, reputable actuary looked at the situation to see what you can put in? Secondly, are you making your children work? The best thing you can do is make your children work, and then you can put them on the payroll, and they have a very low tax rate, and they can open a Roth IRA. Your wages, are you using a wage account? Are you paying fixed monthly periodic wages under an employment agreement? If you don't, then the wages are probably not protected. And are you paying too much in the wages or too little? Then there's dividends, which are not subject to employment taxes. Are you living off of your dividends and banking your wages for creditor protection purposes? Do you have the spouse on the payroll? The spouse's assets are going to be protected. Are you paying rent to a related entity? Are you paying interest to related parties? People, I think, do very well going through this chart and thinking through how their money should flow from their practice. Now, page 31, just an example of why we try to use belts and suspenders and not rely on any one thing. We had a nice charging order law in the state of Florida which always said under the cases that came out that if you got a judgment against somebody, you couldn't reach into the entity if there were multiple members. Well, the Florida Supreme Court got all confused and made a mistaken but binding decision that LLCs would not have charging order protection in Florida. Fortunately, our legislature cleaned that up in June. So we now have charging order protection if you have a multiple member LLC and if it has a proper operating agreement. That's just an example of we don't want to rely on everything. Now, here's a new chart. We're going to go over this in more depth on the Mary Poppins program. But you can use this to show clients that they need several insurance policies. There's your homeowner's policy. There's your car driver policy. There's an umbrella policy that covers liability over $250,000. Those are 3 separate policies, usually issued by 3 separate carriers. Does everyone know what they're doing? Usually not. That vacation home up north may be a 3rd policy. That big boat you have may be a 4th policy. You may need a separate umbrella for that. So Mary Poppins never had so much fun as we have. All right, just to show you what else I have, I've got an umbrella insurance coverage letter. Fill it out. Fill this out on page 34, send it to your insurance agency, and sometimes they'll say, oh, that's the Gassman letter. Darn it, okay, we'll check all this stuff for you. Oh, we found a gap, sorry. In fact, I just reviewed my insurance and I found that for the 2nd year in a row, unbeknownst to us, we have my car covered twice, once personally, once corporately. So the good news is I'm saving $967 this year. The bad news is I can't unsave it from last year, so you just have to be careful with the insurances. Again, every 2 to 4 years you should revisit your plan. I've got an article here on creditor protection for physicians, the most common mistakes, if you ever want to take a look at that. Number 41, is your spouse protected in the trust system we've talked about? Are your children protected? Are you going to have an outright disposition to your children, or are you going to allow them to be protected for their lifetime, which is what we prefer? Are you going to have a good trustee appointed for your children? Have you done your estate tax planning? That estate tax exemption may come back to $1 million January 1, 2013. It would not shock me if that happened. So, going back to the checklist, page 50, I know I've run over my time. I appreciate you listening to this. Please feel free to print this checklist out, and maybe someday we'll have an even longer checklist. Hit the most important 4 or 5 things, then hit the following quarter, hit the next most important 4 or 5 things. Take good care of yourself. and probably most important, have a fantastic day. I really appreciate your attendance and all your ideas.